everybody, welcome back. I'm Glenn.
Michael.
We're Woods and Bates, and we're joining you back here on our video blog, Legally Speaking. End of the year here, so we thought maybe we would just cover a few tips or suggestions to maximize your relationship with your attorney. You want to go ahead and get us started?
Sure. So the attorney-client relationship is typically established whenever a client calls and we speak with them over the phone or we set up an initial consultation. First thing to know is anything you disclose to your attorney is confidential. You have that absolute right to confidentiality in any information you provide us. So I know that is a thought in a lot of people's mind. They're hesitant to talk to an attorney. They don't want it to get out that they've gone out and sought out legal advice, and they're nervous as far as even calling a law firm because they don't want that information out. That information is private and that is confidential, and it will remain confidential. The other thing that we want to think about once we do establish that attorney-client relationship is how do we maximize that relationship so that we're providing the best service we can to you, and so that you feel that all of your questions are answered and there are no concerns or unknowns for you throughout the process, whether that be an estate administration, a divorce case, a real estate transaction. Communication is key to keeping that relationship maximized. So maybe you can give some examples of the best way to keep that communication and maximize the relationship.
Yeah, I think that one definitely goes both ways. I mean, I think it's incumbent on the attorney to communicate with the client. Obviously, as lawyers, we have an obligation to keep our clients informed. We need to keep them informed on, whatever it is, whether what's going on their case. If there's been decisions entered, we need to get that to them. If we get letters in the mail or emails from opposing counsel, we need to get that information forwarded on so we can keep things moving, advising them of what we need to do or what they need to do. And I think that's the other side of that, is that the client needs to communicate with the attorney also. If an attorney has asked the client to do something, the client needs to do that. I mean, the role of the attorney is to protect the client, but the attorney can't really do that unless the client is helping themselves, And I think a lot of that goes with one of the things I thought of, which is to make sure that the fit with your attorney is a good one. I think that you can tell after a meeting or two whether or not that person is going to be a good fit for you. Are you going to get along? Are you going to mesh, I guess, or are you going to clash? Because if you're going to clash, it's not going to be a good relationship.
No, I think that's absolutely right on point. You have to have, whenever you hire an attorney or whenever an attorney takes on a case, it's not just to get a paycheck, or it's not just to go out and say that I got a lawyer. You want to make sure that your relationship, or the relationship between the client and the attorney, is a good one, and that's going to work forward and try to solve that problem. I know we've discussed it before. Typically, people don't call our office unless there's some type of problem and they're looking for us to help solve that problem. Well, as Glenn mentioned, after a couple meetings, if we come to an impasse on how we want to handle the case versus how you would like things to progress forward, then maybe it's not the best fit, and maybe the client and the attorney need to part ways at that time. I think one of the points Glenn and I were talking about, he firmly believes that the attorney themselves has to believe in the case that they're arguing for or against. I mean, we can't go over, I find it hard in my profession to go over and argue a point of issue in front of a judge that I don't necessarily personally believe in. And that's difficult because a lot of times as attorneys, we're arguing competing theories on a daily or even hourly basis. And if we aren't believing in what we're arguing, then it's not going to be a good fit for the client. And I think that relationship needs to be there mutually both ways.
I think that's right. I think that gets easier the longer that you do the job. I think that somebody that's coming right out of law school has hundreds of thousands of dollars of student loans. They may not totally believe in the case, but they probably believe in making their loan payments and
right.
their mortgage payment and things like that. But it's tough. It's a tough thing because it's a profession. It's also a business. But if you believe you have a lawyer that doesn't believe in what they're fighting for, I think you ought to be able to tell that right away. And there's always other options out there. It's one of the things that I wrote down as I was thinking about this is it's always the client's option who they want to represent them. You're never going to be stuck with whoever it is you first met with. But I think making sure it's a good fit, communicating. One of the things I think of a lot is things that an individual client may think are not important may be very important. I guess that's one of the things with candor I think of is making sure you're sharing with your attorney all the details of the case, even if you think it's not important, because it could be, and we or they will know that pretty quickly.
Yeah, and I think that goes back towards the first point of confidentiality. Anything that you disclose to us will remain confidential. Just because you're disclosing a piece of information to us does not mean that that piece of information will be presented to the judge or the opposing party or anybody else outside of this office for that matter. And as Blinn says, be very candid with the information that you provide us. Don't withhold information from us because you believe that it would turn us away from taking your case. If we receive that information, or rather we need that information if we're going to represent you in a competent manner. We can't, in a situation for me, do a lot of divorce and custody work. I show up at trial and there's this smoking gun text message video that I've never been made aware of, then I can't do my job and effectively represent you if I don't know that information exists. So I think over disclosing to your attorney is not going to be detrimental to you. That information is protected by the attorney-client privilege and it will remain confidential.
And I think a lot of that comes with just establishing a connection and establishing trust in the relationship. I think that maybe there is some information that may be embarrassing or you don't want to share it or whatever, but it's important to remember that the attorney and client relationship is a team. I mean, you're working together, you're not working against each other. If you're working against each other, you got a problem. One of the things that comes up a lot, I think, is a big bone of contention a lot of times is fees, how you're going to be charged. And in my opinion, those are things that should be fleshed out in the very first meeting that the attorney and the client have. Those are things that should be in writing. A lot of times our rules of ethics require that they be in writing. I know you're a lot better at this than I am, but getting retainer agreements and outlining, here's the representation, here's how it's going to be billed, whether that be at an hourly rate, here's the hourly rate. If it's a flat fee, here's the fee, here's the contingency fee, all those things in writing and signed by the parties so that everybody's on the same page. I think those establish some good relationship and some good boundaries so that everybody knows what everybody's supposed to be doing.
Yeah, at the end of the case, you send a bill out to your client. You don't want them to feel surprised or feel like you've taken advantage of them. You want to make sure that that fee structure you agree to with your client or the client agrees to with their attorney at the very outset. As Blinn said, it could be a matter where we take on, it's a flat fee. We're not billing you an hourly rate. You pay X amount of dollars, and that takes you from the beginning to the end of your case. We can take on cases at an hourly rate. We keep track of our time. At the end of the case, we bill you against our hourly rate. Or the last typical fee structure would be a contingent fee agreement where the attorney won't get paid unless the client recovers some type of damages. And as Blinn mentioned, make sure those agreements are in writing. It not only protects you, but it protects the attorney. Our ethical rules require us, anytime we take a retainer, payment to have a written agreement and to provide a document to the clients that is titled the Statement of Clients' Rights and Responsibilities. So that puts us at a equal playing field at the very beginning of the case. Each person, or the client and the attorney, both know what are the rights and responsibilities of the client and what are the rights and responsibilities of the attorney. And if we're asking for information to be provided, we can't do our jobs unless you provide that information, and vice versa. If you need to contact us and you need to have answers before you decide whether or not you want to move forward with your case, then there has to be that communication, and it has to go both ways. If you receive phone calls from your attorney or emails from your attorney, return those phone calls, return those emails, and it's likely that your attorney is doing the same when you reach out to them.
I think it's always a good idea to have contracts. I mean, that's why we draft contracts, so everybody knows what they're supposed to do. I think a part of that too is making sure that the fee arrangement is appropriate. I mean, if you've got somebody that's working on a contingency fee in a divorce case, that's a problem. You can't do that.
I think it's even prohibited by our ethical rules.
It's prohibited, absolutely. But there is a time and a place for a contingency fee, and it's used. But you need to know what that is when you get into the representation. You know, and I think overall, I guess, client's the one kind of driving the ship a lot of the times. You know, they get to choose who's going to represent them, who's going to handle their matter in civil cases, which is what we do.
Mm-hmm.
You may not have that option if you're sitting in prison, but you know, I think being open, being honest, making sure that the relationship is establishing trust between the parties, everybody's doing what they're supposed to be doing, you're going to have a pretty good relationship, and you can have good results, I think, with that type of relationship.
Absolutely. And I think final thought to keep in mind is when we're working for you, the information that you have in your mind, or the information that you have that you've shared with your family, your case is special to you. If it's a divorce or custody case, you've been living that life with that child. You know all the family members, all the players in this controversy. That information might not be that information or those situations might not stand out on our notes after we meet. And it's important to understand that something that might be common sense or second nature in your mind, that piece of information you need to provide to us, whether it's an estate administration and knowing how the farm previously operated. That information you might know, and you might share that with your family, but you need to keep the attorneys informed so that they can, again, have an idea of the full picture rather than just the bits and pieces of information that is provided through an initial consultation or any subsequent meetings.
And I think a lot of that goes back to expectations, establishing expectations of what we're going to do and how we're going to do it, and who's going to provide what information. You know, I don't read minds, unfortunately. Don't have a crystal ball, unfortunately, and clients don't either. I mean, Clients don't read minds. There's a lot going on up here a lot of times that, you know, these wheels start turning and not a lot of that gets spit out when it should. But that all comes from different experiences and different circumstances. I mean, we haven't lived the situation of the client, and the client hasn't lived through a lot of other cases to establish the knowledge that we have, and that's why we're coming together to hopefully try to achieve a common goal.
It is a complex court system, and it's better to navigate it with somebody that's a professional in that system. And again, that goes back towards, even though attorneys may think that some of the things in our profession relating to the court system, again, might be common knowledge for us, but we have to keep our clients informed and let them know why we are doing certain things. So I think that mutual exchange of information is great for everybody. More information is always better than less.
I agree. What's going on in the world of sports? Railers are undefeated.
I saw that. I saw they put on a pretty good beating last night to Mattoon. A lot of young guys got some action in the second half last night. And U of I, top 5 matchup tonight.
Michigan.
Big Blue.
Think you can get them?
A lot of top 5 teams falling here recently in the college basketball world, so we'll see. Illinois has been playing tough.
They almost beat Maryland.
And then Maryland, I believe, got beat last night, so we'll see what they can do tonight.
How's Sparty doing?
Not off to the greatest start, but they're a tournament team, so plenty of confidence they'll be there in March when they need to be.
My son's rec team is the Spartans, so we're undefeated.
Nice. Nice.
All right, guys. You guys have a good holiday, and we will see you again next year. Thanks.
Take care.